Welcome back to our subject, Human Rights Education. And today, our lecture is on the writ of habeas corpus and the right against self-incrimination, as well as the non-detention clause and the involuntary servitude clause. So at the end of this lecture, the viewers are expected to understand the concepts and exemptions of the writ of habeas corpus, as well as to understand the concepts of the right against self-incrimination and to be able to explain the right against involuntary servitude. So what is the writ of habeas corpus? Section 15 of Article 3 of the Philippine Constitution, it states that the privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. So when you say writ of habeas corpus, that is now the presentation of the body of the detained person, as well as the order to the law enforcement officer to justify or to explain the cause of the detention. So that will not be suspended. Say, for example, if you think that you are illegally detained, what are the basis of legal detention? Well, the basis of legal detention are the following: commission of a crime, okay, order of a competent authority, as well as the if you are suffering from violent insanity. So those are the valid reasons to make the detention valid. If you think that you did not commit any crime, if you think that that your detention is illegal, then you can question your detention, as well as your relatives can ask for the presentation of your body. However, uh, that can be lifted up, or that can be suspended if there is an invasion, when there is a rebellion, and when the public safety requires, particularly when there's already a lawless violence in the country. So the president of the country suspended the writ of habeas corpus for the sole reason that there is a threat given by an opposing country that they will invade the sovereignty of the country. Is the suspension valid and constitutional? So there is now what you call a threat of invasion, meaning a country said that we are going to attack you. Okay. So for example, the China says we are going to attack you. Okay, we are going to invade your country. So there is a threat. Now, so the president suspended the writ of habeas corpus, particularly those people who are, we call it, presently detained, and the detention is questionable. So is the suspension valid and constitutional? Well, the answer is the act of the president is unconstitutional. Before the writ of habeas corpus be suspended, there must be an actual invasion, not just a threat of invasion. Okay? So remember that. There must be an actual, meaning andyan na sila, parating na sila. Okay? Hindi yung sali-salita lang, no? Wala man lang declaration of war. Okay? Just a threat that we are going to invade you. So that will become unconstitutional. So what is that writ of habeas corpus again? An order by a competent court. It's a competent court, meaning that is the court that is authorized to issue such um, habeas corpus, or to issue that order directing a person detaining another, requiring the former, okay, to produce the body of the detainee at a designated time and place. So the former means the law enforcement officers or the officers, okay, the police officers. Say for example, the court will order them to produce the body of the detainee, okay, at a designated time and place, and show cause, meaning to show cause and explain the reason for such detention. That is to show that if ever they detain the person, they have to explain that the detention is covered by a valid reason. So it is the best and sufficient remedy by judicial decree, okay, to secure the freedom of an illegal detained person. So if you think that your relative is illegally detained, then that is the best and sufficient remedy. Okay, sufficient remedy, okay, by judicial decree. So that you can secure now the freedom, meaning pwede mo nang may palabas yung relative mo na nakulong if the detention is invalid. But otherwise, the writ of habeas corpus cannot be applied in that particular situation. Further, the writ of habeas corpus is a best prerogative, or it can be a prerogative or alternative. Okay, alternative writ of liberty employed to test the validity of a person's detention. That is actually para ma-verify mo or ma-check mo, mapilitan yung law enforcement officers na mag-explain or magpakita ng tawag natin ng ebidensya na talagang legal yung kumbaga yung kanilang pag-arrest at pag-detain sa yung relative na nakulong. Okay? So at the same time, it can test now, no? Kung totoo nga o hindi. From their explanation, at least there you can now determine whether the detention is valid or not. And the writ of habeas corpus can be considered as the ultimate purpose of the writ of habeas corpus is to relieve a person from unlawful restraint. So remember that no person shall be deprived of his right to liberty, right to life, liberty, and property without due process of law. So the detention must be within the scope of the due process of law, or within the scope of valid grounds for detention and arresting a person. Okay? And the writ of habeas corpus shall extend to all cases of illegal confinement. So all cases of illegal confinement or detention by which any person is deprived of his liberty, or by which the rightful custody of any person is held or withheld from the person entitled thereto. Okay? So lahat ng illegal confinement. Okay? Nahuli yan, no? Kinulong yan sa city jail, sa municipal jail, sa provincial jail, wherever, no? That could be, we call it applicable, so long as you believe that you think and you have an evidence that the detention is illegal, then you can use the writ of habeas corpus as a remedy. You will apply that sa competent court. Mag-apply ka doon. Okay? Yung nakaka-cover sa lugar na yan. Para mag-issue ngayon ng order. Now, on the other hand, we have to repeat again the right against self-incrimination. So we already discussed that no person shall be compelled to be a witness against himself. Okay? So hindi ka pwedeng maging witness ng sarili mo. So self-incrimination refers to acts or declarations either as testimony at the trial or prior to trial by which one implicates himself in a crime. Okay? So yung sa custodial interrogation, okay, pinilit ka magsalita na yung mga sasabihin mo ay relevant at directed sa kaso na nag-i-imply ng yung participation or yung guilt. So hindi pwede yan, ano? And that right is available not only in criminal prosecution, even in all other government proceedings, including civil actions. Kinasuan ka dun sa ng administrative case, ng civil case, okay? Lahat yan ay pwede mong invoke yung right mo to remain silent and not to force you to say anything that may implicate your guilt on the case at bar. Okay? Even administrative or legislative investigation. Even doon sa tawag natin sa ongoing na hearing ng red tagging sa Senado. So for example, ongoing pa siya, no? Pero tapos na. Okay, assuming merong ongoing pa rin yung red tagging controversy or red tagging investigation sa Senado, even in that particular hearing na ginagawa ng Kongreso at saka Senado, you can invoke your right against self-incrimination. Okay? Not only by the person accused of an offense, even by any witnesses to whom an incriminating question is addressed. Kahit witness ka, no? Kasi mayroon tayong tinatawag na mga hostile witness. Ito yung mga witness na maaring may kinalaman dun sa tawag natin sa criminal act under investigation, no? So, pwede rin sa kanila, kung sinasabi mong I have the right to remain silent or kausapin ko muna abogado ko, hindi ka nila pwedeng pilitin dyan kasi you have that right na huwag mong sirain yung reputasyon mo or yung dignidad mo. As long as the question will tend to incriminate. So mayroong tendency lang na ma-incriminate ka or ma-implicate ka doon sa kaso. The witness entitled to the privilege. And in all other cases, he may not refuse to answer, provided the question is relevant and otherwise allowed, even if the answer may tend to embarrass him or subject to him to civil liability. What does it mean by that? In all other cases, he may not refuse to answer. Provided the question is relevant and otherwise allowed, even if the answer may tend to embarrass him or subject to him to civil liability. Meaning, okay, ay maaring hindi siya sumagot, or maaring sagutin niya. Okay? Yun ang ibig sabihin. Provided na yung mga question ay nakakaimbara sa kanya. So, hindi siya, nasa kanya yun kung sasagot siya o hindi. Now, this is now one of the cases. Mark was arrested for committing the crime of rape. While in the police station, police officers Donald and Nilsson, through force and intimidation, compelled Mark to give his statement against himself to be used in the case that the said officers will be going to file in court. Is the action of the police officers constitutional? Obviously unconstitutional. Okay, so why? The act of the police officers violates Section 12 and Section 17, the right against self-incrimination. Okay? And of course, the right of a person under custodial investigation, no? Yung compelling, vitiating his free will. No? So, may violation doon. So, obvious na gano'n. Pag hindi pwedeng i-compel, mas kailangan yan ay voluntary yung mga statement. Kapag hindi voluntary yan, it will become inadmissible as evidence in the court. Remember your doctrine of the poisonous tree or the poisonous tree doctrine and the exclusionary rules in criminal proceedings. Now we have the non-detention and involuntary servitude clause. Section 18, there are two paragraphs. No person shall be detained solely by reason of his political beliefs and aspiration. And the second paragraph, no involuntary servitude in any form shall exist except as punishment for a crime whereof the party shall have been duly convicted. Okay, this provision of the Constitution protects the right of anyone's liberty, because if you are going to involuntarily serve a person, somehow you are deprived of your liberty, your freedom. At the same time, okay, it is tantamount to slavery, and that will now affect your dignity as a person also. Okay, so what else? Your political belief. Okay, that is what you call, you should not be imprisoned by that, because under the Philippine Constitution, nakalagay na dyan na wala ng tao na sa Section 18 na wala ng tao na may kukulong dahil sa kanyang political belief. That's why even obviously that the Anakbayan and the Makabayan blacks are left-leaning groups, or obviously even if they are denying it, it is very obvious that they are part of the Communist Party of the Philippines. Well, they do not violate any law for that matter, because the Constitution guarantees their political belief and aspirations will not cause their detention or imprisonment. Okay? Kaya lang ayaw nilang aminin yung pagiging part nila ng komunista because of the conspiracy theory. Okay? Sa conspiracy theory na the act of one is the act of all. In that case, no? Kaya kapag inamin nila na sila ay mga komunista, well, babato sa kanila yung mga terroristic activities ng NPA because of the conspiracy theory, no? Kaya ayaw nilang aminin doon. That is one of the reasons kaya ayaw nilang aminin. So the non-detention clause, no one, the paragraph 1, no one should be detained if the reason is only a political belief and aspiration. So once a person voices out his opinion about his contentment and discontentment to the government, that person cannot be detained or imprisoned because that person is only giving a comment as to her or her satisfaction to the services provided by the government. Yan. So kahit mag-rally kayo, sasabihin nyo na palpak si Duterte, hindi kayo basta ikukulong, basta wala kayong batas na violate, di kayo nagbabandal, no? Di kayo nagsisira ng mga private and government properties. Okay, so you are just only airing your sentiments, your political belief and aspirations. However, take note that particular non-detention clause is not absolute because as I've said, uh, depende ngayon sa sinasabi mo, no? Depende ngayon sa content in your freedom of speech, depende ngayon sa sinasabi mo whether there is what you call a dangerous thing that you are saying, you are inciting somebody to commit a felony. So there are exemptions to the rule which we have already discussed in our earlier discussions or lectures. Okay, so because of that, the police authorities can apprehend the members of the RRG. No? Why? Because the right under Section 18 will not be violated because this one is one of the exemptions. It is true that the members of the RRG exercise their freedom of speech. However, what is the content? Okay, the content of their statement is of a criminal nature. As I mentioned a while back, it will result to a crime known as inciting a rebellion or insurrection defined and penalized under Article 138 of the revised Penal Code. Okay, so that freedom of speech, is not an absolute. There are exemptions to the rule, as we have discussed so many times in this lecture series. What about the involuntary servitude clause? Okay, what does it mean by the word involuntary servitude? In the definition of uslegal.com, involuntary servitude refers to being forced through coercion to work for another. So you are forced against your will to work for another. Okay, this term is sometimes equated with slavery. So para siyang slavery, pang-aalipin. Under the Constitution, involuntary servitude is expressly prohibited. No one should serve another person through compulsion because it negates human dignity. So hindi mo pwedeng pilitin na magtrabaho sa'yo, no, kung ayaw niya. No? Huwag pilitin yan. Unless siguro may kontrata na kailangan niyang magtrabaho, na mayroon siyang dapat itrabaho. No? That is another thing siguro na maaring titignan later on. So here comes another issue. Senator Bernie, in his privileged speech at the Senate exposed therein that President Arabaca corrupted a sum of money amounting to 2 million pesos and used it for his personal gain. Senator Bernie even said that he should be removed from office as the president of the country because he is not a competent leader, as well as the members of his cabinet. After the said privileged speech, police authorities arrested Senator Bernie and for what he did. Are there any violations in this scenario? Violations by Senator Bernie and violations by the police authorities. Okay. So in that particular case, the police officers violated the Section 18, Paragraph 1, Article 3 of the Philippine Constitution. Senator Bernie is immune from any arrest for making a privileged speech in the Senate, even if the words used are derogatory. You call that the Parliamentary Immunity. Okay, so what is the concept behind? Well, we can see that under Section 11, Article 6 of the Constitution, providing as follows: a senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in Congress or in any committee thereof. That's why you notice that the Makabayan Bloc, they have the history of uttering, delivering their privileged speech in the Congress, in the House of Representatives, derogatory remarks against the government. Well, they are not being arrested for that because they are immune from prosecution. That's why yung mga senador at mga congressman na ayaw sa government natin, ginagamit nila yung kanilang plenary hall, ginagamit nila yung kanilang privilege speech, no, na pang-atake sa government. So they are very cautious in speaking to the public. Particularly sa mga media, baka mamaya makasuhan sila ng libel or oral defamation or whatever crime it is. So they normally use now the House of Representatives and the Senate sa kanilang gagawin to attack the government. Again, provided that their statement does not incite the people to go or to commit rebellion against the government. So in Vera versus Abilino, the Supreme Court, quoting a decision of the United States Supreme Court, explained for whose benefit the right to parliamentary immunity is secured. The privileges are thus secured not with the intention of protecting the members against prosecutors for their own benefit, but rather to support the rights of the people, meaning they are representing the people. So there is now an implication that what they are saying is a representative of the sentiments of the people. Okay, so by enabling the representatives to execute the function of their office without fear or prosecution. So, if in case there are things that are not good in the government, okay, so the implication there is that's part of their function. So they are immune from prosecution. And finally, what does the Bible say about slavery, no? Kasi pinag-usapan natin yung involuntary servitude, which is tantamount to slavery. In Leviticus chapter 25 verse 39, it says there, if any of your fellow Israelites become poor and sell themselves to you, pinagbilin sarili nila, do not make them work as slaves. Okay? Although sa Bible yan, ang slavery, napaka isang critical na issue yan kasi may mga slaves naman sa Bible, no? However, class, sinasabi pa rin doon ng ating Bible na kung maaari ay wag mo silang gawing alipin. No? Yung they will involuntary serve you na halos hindi na sila nagsesweldo, no? Halos di sila kakain. So yun ang ayaw naman. Yan naman ang ayaw ng ating Diyos na nakasaad doon sa Bible. Okay, so once again, thank you for listening. May the Lord bless us all.